We'll start our questions with Mr. Caputo. Mr. Caputo, go ahead, please. 6 minutes.
Thank you, and I appreciate all of the witnesses being here. Through you, Chair, I direct the following questions to Minister LeBlanc. The NSCOP report that was recently released reveals that parliamentarians, including members of our House and the House of Commons, knowingly and deliberately assisted a hostile foreign state to the detriment of the people of Canada. This places a cloud of suspicion over every single member of the House, elected members. Do you know the names of these people?
Mr. Chair, through you to Mr. Caputo, thank you for the question. I am updated regularly, and I think in a complete way, by our intelligence agencies, by the RCMP, by the Department of Public Safety. So I am very comfortable that I have the information that I need to do the work that I have to do, but you'll understand that discussing the details, particularly of the most sensitive information, is not something that we want to do publicly.
Well, I'm not asking you to discuss sensitive information. I'm asking whether you know the names. Do you know the names, yes or no?
I know a number of names that were surfaced in various intelligence products that I have seen, but I was not in the room when the Committee of Parliamentarians did their work. I don't have the exact details of which documents they saw and didn't see, but I'm very comfortable that I have access to all of the most important intelligence information, which would include, in some cases, names.
Okay. So people who are alleged, and in some cases, according to our intelligence communities, to have committed some of the most serious offenses known to Canadian law, are you prepared to release those names, yes or no?
No, Mr. Chair.
You will not release the names of members, elected members, operating in the House of Commons. Do you think Canadians have a right to know, yes or no?
Mr. Chair, I think it's important for Canadians to understand that these names are contained in intelligence reports. In some cases, it's uncorroborated or unverified intelligence information. I think we would need to be very careful to understand that, as the director himself has said, intelligence is often a series of pieces of a puzzle. One particular piece of the puzzle, an intelligence source or information, may not have a context, may be discredited or altered by subsequent information. So the idea that there's a perfect list of names that is entirely reliable that should be released to the public is simply irresponsible.
Minister, the NSCOP report doesn't equivocate like you just did. The NSCOP report is clear, incredibly clear on names. Do you think Canadians should have the right to know?
Not actually clear on names.
I'm not done my
Mr.
question,
Chair.
Minister. Do you think Canadians have the right to know when they go to cast an X next to the name of somebody in the next 15 months, the very thing that we're dealing with here in Bill C-70, do you think they have the right to know whether their member is under the influence of a hostile foreign state? Yes or no?
Mr. Chair, I think Canadians know, and I'm confident that they have every reason to be reassured that our intelligence agencies and the RCMP take their responsibilities extraordinarily seriously, have the resources necessary to investigate, and should the RCMP, for example, in their wisdom, decide that charges should be laid in consultation with the appropriate prosecutors, that's our system in a rule of law democracy. It's not simply releasing a series of names or doing, as Mr. Caputo says he's concerned about, casting aspersions himself on everybody by pretending that there's some perfect list of names that the government's not releasing. No other Western democracy knows this, and Mr. Caputo knows that certainly in the government of Mr. Harper, even that kind of conversation wouldn't have been conceivable. So I think there's a certain disingenuous element, Mr. Chair, in Mr. Caputo's theatrics this morning.
Disingenuous element. Under Mr. Harper's government, we did not get a report that said foreign state actors had infiltrated. Under Mr. Harper's government, we did not have reports saying that foreign state actors had dealt with this. Now, Under current legislation, you can disclose top secret information when in the public interest. What would be more in the public interest than a person who could be elected and they are under the thumb of a hostile state actor? You can do that. So when you talk about disingenuous, you can do this. Why won't you before the next election?
Mr. Chair, speaking of disingenuous, in Mr. Harper's government, the National Security Committee of Parliamentarians didn't exist because Mr. Harper's government didn't believe that parliamentarians should have access to this information or be able to review the work of our intelligence agencies. Mr. Harper's government in 2013, CSIS publicly identified an increasing risk of foreign interference in our democratic institutions, and the Harper government did absolutely nothing. So again,
Chair,
Mr. Chair, I think it's
order.
important to have a context to these comments.
So you are okay with us going into an election, people putting an X beside a name where they have a cloud of suspicion, every single one of us. Let's face it, Minister, I think if there were six Conservatives on that list and no other Liberals, we would have had the names. Let's be honest here.
Thank you, Mr. Caputo. The
No,
Minister
pardon
may
me,
answer.
I think I have another minute here.
No, you
No?
don't.
Okay, thank you. I'm sorry.
The Minister may answer if you wish.
Mr. Chair, again, Mr. Caputo makes something up. If there were 6 Conservatives and no other political parties, of course we would release the list. Mr. Chair, I'm not going to violate the Security of Information Act and risk prosecution for a political stunt, and I think Mr. Caputo knows better.
We go now to Mr. Gahir. 6 minutes, please.
Great. Thank you, Chair, and thank you to all the witnesses for appearing before the committee. Minister, I wanted to focus on foreign interference and its impact on diaspora communities, something that Mr. Virani actually touched on in his opening testimony. I know you've spoken about in the past as well.
Point of order, Chair.
Mr. Dennis on point of order.
Thank you, Chair. During Mr. Caputo's round at the end, Ms. O'Connell was literally shouting at him across the floor, and now she's saying, "Boo-hoo, get over it."
Thank you.
Respectfully,
Thank you.
Chair,
Thank you.
I think you should call this member to order. It is a point of order.
Thank you.
You're shouting.
Mr. Dennis.
Shouting
Mr.
at another
Dennis.
member. No, sorry, I've got a point of
Speak
order.
to the chair, please.
Great.
I hear your point of order. I
Thank
would
you.
encourage all members to not talk across the table,
Yeah.
to talk through the chair when they're recognized. It would be helpful to us all.
I hope you'll call
Mr.
Ms. O'Connell to order because she wasn't cross-talking. She was shouting in order to disrupt Mr. Caputo's round of questions.
Mr. Gahir, go ahead, please.
Great. Thank you, Chair. So I wanted to focus on foreign interference and its impact on diaspora communities. We've had different groups come and raise that concern as well. One of the groups that came was the World Trade Organization. They largely were in favor of this bill. They said more needs to be done to counter foreign interference. In that respect, Bill C-70 is a step in the right direction. They did want to highlight, however, that CSIS would have the ability to disclose information to any person or entity should CSIS deem that relevant. This would be a great step. They are concerned that whether foreign consular officials in Canada would count under entity and what kind of information could be disclosed to them, and whether diaspora communities could be put at risk because of that disclosure.
Mr. Chair, through you, Mr. Gahir, thank you for the question. Thank you for highlighting what I think all of us would properly be concerned about is the impact on diaspora communities in Canada. You're absolutely right. They are often victims and targets of this foreign interference. We've seen publicly reported cases that should worry all of us. So that is, I think, one of the reasons why it would be terrific if Parliament was able to strengthen in the appropriate way with the right safeguards the ability of our agencies to protect these communities, to protect Canadians. And you and I had a chance, Mr. Gahir, to talk about this specific element in terms of what information could properly be shared with different foreign governments or consular agents. I know that there are agreements that govern, and properly so, these kind of sharing arrangements. I think we can agree that the kind of information, and I'm speaking for my RCMP and CSIS colleagues, but I hope they won't disagree, the kind of information we might share, for example, with Five Eyes partners is different than we might share with a particular country that's interfering in an illegal and inappropriate way in Canadian affairs. But if you'd allow me, Mr. Chair, the Director of CSIS, Monsieur Vigneault, will be able to give, I hope, the precise answer to Mr. Gahir's very proper question.
Thank you, Mr. Chair. Thank you, Minister. I think the member points to something that is extremely important in the debate on foreign interference. There was a lot of focus on electoral interference, but minority communities have been targeted, continue to be targeted by foreign states, and that's why it's so important that we have the proper tools. In terms of information sharing, Mr. Chair, I can assure the member that there are very specific and reviewable guidelines under the Avoiding Mistreatment by Foreign State Act that govern the way we share information, and it is being reviewed annually by the National Security and Intelligence Review Agency, and we take this extremely seriously to make sure that we do not share information that would potentially harm Canadians.
Great, thank you. So what I'm hearing is there are the proper checks and balances before that information is obviously disclosed. The other point that was raised is there is a framework for cooperation on countering terrorism and violent extremism between Canada and India. That is still active. I think it was 2018 when that agreement was signed. When that agreement was signed, there was members of different diaspora communities, the Sikh community, for example, that had certain hesitations about that agreement. And so, those fears were heightened when news came out of Hardeep Singh Nijjar's killing in BC when the Prime Minister stood up in Parliament, and we all witnessed it. So the community is asking, and WSO is asking, what information is that agreement still active, and what information is being shared under that agreement, and is information being shared, or could it be shared that puts individuals in danger, whether they're here in Canada or their families are overseas in India?
Mr. Chair, again, a very good question. I think it would be important to reassure the community that the appropriate protocols are in place and that their interests and their security is obviously paramount in any decisions that our security agencies might undertake. I don't, perhaps the director of CSIS or the deputy commissioner of the RCMP, because there would be, I assume, a criminal, in the case of a criminal investigation, for example, Mr. Nijjar versus a terrorism investigation. But, Mr. Chair, if, with your indulgence, I think the director of CSIS and the deputy commissioner of the RCMP could provide exactly the information our colleague wants.
Mr. Chair, I'm happy to take that question. So within the RCMP, and I know my colleagues at CSIS and other departments have similar processes, we have a process that ensures there is a proper risk assessment and independent individuals who are not part of those investigations are brought in to analyze the information, the request for information, and our responses to those to ensure that any information that we are going to share with any foreign entity is properly assessed to ensure that it will not cause jeopardy to any individual, and that's any individual, whether Canadian or otherwise. I recognize the concern that is raised, and it's something that we as law enforcement and security and intelligence officials have to deal with every day. It is a global community. There is many problems that are global in nature, and the reality is we do have to communicate with people and with countries that do not have the same values and ethics as Canadians and as in Canada as a whole. However, I can assure you that we take all of those engagements very seriously, and we exercise extreme caution in all of those engagements.
Thank you, Mr. Gahir. Yeah. We go now to, on y va maintenant, Monsieur Villemure.
We will now turn to Mr. Villemure. You have the floor, sir, for 6 minutes. Thank you very much, Chair, and thank you all for being here. Many of you, indeed, highly impressive. My questions are for Mr. Virani, but I'll begin with Mr. LeBlanc, if you don't mind. Mr. LeBlanc, I've been following this file, foreign interference, very closely for quite a while, and I understand your answers, to the effect that you cannot provide a list of names. The nature of the information, secret, top secret, and highest secret, must be respected. So, understood. We're not requiring that you make this information public. We understand the situation. However, we're wondering what may occur. Can you give us a bit of an overview? The impression we have is that in the past, people were slow to react. The special reporter, et cetera, there were documents that weren't necessarily shared. with the public inquiry, for example. Given the importance of this issue that you have underscored and your interest in sharing information that you can, what can we expect? So through you, Chair, to Mr. Villemure. Excuse me? Excuse me, we're not receiving the interpretation on Zoom. So please resume, sir. Thank you, Chair. Very well. Mr. Leblanc, then I turn back to you. So what's your answer to my question? Mr. Villemure, thank you for your question. Thank you as well for your work and your party's work in support of the bill and to improve the bill as well. I fully understand the meaning of your question, how sincere it is, and I applaud your wish to ensure that we do everything as well as we can. You're right, and you have touched on the reasons for which it's not possible to give some sort of magical list of names, but it's important to reassure Canadians that the highest democratic institution of our country, the House of Commons, that we have the privilege to sit in, be, as much as we can possibly ensure, safeguarded from foreign interference, and to ensure that anyone who gets involved in foreign interference is held accountable. Without being overly dramatic, I believe that because I've had the privilege in my position as Minister of Public Safety I've been able to work with our security agencies, our intelligence agencies, and I'm fully confident that anyone trying to do something that's illegal, that harms Canada, will be held accountable. Of course, in the election process, we have the Canada Elections Act. We have a number of mechanisms. You referred to the Hague Commission. Correctly so. I worked with great pleasure with your parliamentary leader, Mr. Terrien, last summer to create the Hague Public Inquiry, and I'm very interested in their work. I look forward to receiving their reports. We had the NCCOP work of this week and the review agency as well, the NSIRA, and we're looking forward to any amendments you have to the current bill before Parliament. Of course, the aim and the deep wish is to reassure Canadians, our institutions and our partners and the security agencies that we have all the means available to counter this threat. We look forward to the Hague Public Inquiry results, and we may have a little time left to improve and to bring down new bills. So we're on the mark, ready to go, do everything we can to help Canadians and to reassure them as well. We do not want to leave Canadians with the impression that there are any members of our House who are not accountable under law. Everything will be done as appropriate. Yes, but you will understand that in the past, it often took a long time for solutions to be seen on the horizon. You know, confidence, transparency, and exemplary action. That's what we're hoping for. Now, back to the bill. Oddly, this bill doesn't seem to actually define foreign interference. There are a few definitions we can kind of make out given how it's used in the text, but there's no actual definition, and something that's not defined doesn't really exist, right? Well, you're right on that. In my discussions with my colleagues at the department and with our partners in the security agencies, that question came up. Of course, there will be lawsuits, criminal lawsuits over the years, and basically the courts, as they must, will define the elements of the criminal offense. That's the way legislation and law works in Canada. There are also new tactics continuously being developed inasmuch as the threat evolves month by month and year by year, given the new technologies. The definition is shifting, let's say, so defining it specifically might have restricted the application of the legislation. But I have full confidence in our partners. Thank you very much. Mr. Pirani, I'm not a criminal law expert, but yesterday we had a criminal specialist tell us about very specific sections of this bill which she felt were imprecise, too unclear to be able to be dealt with so quickly. So I must say that I, therefore, am uncomfortable changing the criminal code so quickly. I can't argue on each of the sections and amendments to the criminal code, but the concern was that there were some elements that weren't precise, perhaps some unexpected results should we adopt these changes to the criminal code. So what could you do to help us to do our work appropriately? And I think that working really quickly is not the best way forward. Thank you for the question, Mr. Villemure. I can add a couple of things here. First, with the changes to the legislation of 2016, I believe, it's necessary to table in the House statements about any ways in which a bill affects the Charter of Rights and Freedoms. So that's already done. And you've brought up a context in which any freedom might be at issue, but yes, that must be discussed openly in the House and specified. So here we have written a bill influenced by our in-depth consultations, and this is a delicate matter, of course, but it's also a matter of the highest importance for Canada. And it's a priority to modernize our legislation, in particular with regard to sabotage, the act of sabotage. Thank you, sir. Don't you think we're moving too quickly, though, that as parliamentarians we're not able to weigh this in depth? Thank you. Thank you, sir. I'm so sorry. Your time is up.
We will start our second round. Oh, sorry. I'm way ahead of myself. I apologize. Mr. McGregor, if you would please go ahead with 6 minutes.
It's a consequence of these new long table setups. I get lost in the mix here. Thank you, Mr. Chair, and thank you to our witnesses for joining us and helping guide this committee through this really important study. Minister Varani, I'd like to start with you. I have some questions about the amendments to the Security of Information Act, otherwise known as SOIA. Now, in the existing SOIA under Section 24, it says that no prosecution shall be commenced for an offense against this act without the consent of the Attorney General, meaning yourself. I guess I just have a question because there are some very consequential amendments to SOIA in this bill, particularly the new Section 20.4 that's going to be added with respect to political interference for a foreign entity. I mean, I'm just looking ahead. The position of Attorney General is filled by an elected member of Parliament, and I'm just wondering, would it not be safe to maybe remove the requirement for the consent of the Attorney General, given that you're dealing with offenses here that are of a political nature? Would it not be better to perhaps lead that to a senior civil servant? Do you have any thoughts on that?
I do. Thank you, Mr. McGregor. It's an important point. I'd say a couple of things. One is that AG consent is in various places throughout the criminal code. We can talk about the context of a prosecution for some of the hate propaganda offenses, for example. It's in the code for specific reasons, but primarily as a safeguard. When we express an understanding, we want the code to reflect that understanding, that the interests that are in play are very, very significant. And when you're talking about potential restraints of charter rights in the context of something that might have been orchestrated by a foreign nation, I think you're talking about very serious crimes as opposed to a simple break and enter or uttering threats. The last piece I would also say is that I appreciate your point. I would reflect on the fact that we had a pretty extensive analysis of the division of the role between AG and the Minister of Justice, and that was done by a former Attorney General herself, Anne McClellan. She talked about how the system that we have can continue to work. But I think actually having somebody with a person such as in my role right now reflecting on it is important insofar as What we're also dealing with when we're dealing with foreign interference is potentially very sensitive information of the type described by Minister LeBlanc that deals with sensitive state relation matters, both with the state that's at issue, but also with the other states that may have been cooperating with us to provide us the intelligence. I think given that aspect, I think it's very important for somebody who has a political lens to actually provide input as to whether the prosecution should or should not proceed.
Thank you for that. I also have another question dealing with this same clause in the bill, and Clause 53 is a very big clause. But now the amendment to Section 20 of the SOIA, where it's talking about intimidation, threats, or violence, and we have the word intimidation inserted in there. I've heard concerns from some groups that intimidation is not defined in the SOIA. That could be hugely problematic, and because it could be open to interpretation. For example, if you have two groups who may have foreign association but are at different ends of the political spectrum, is there not a danger that a government of differing political natures may see those two groups in different lights? Like, how do you define intimidation? Is that not problematic, not narrowing it down further?
Thank you for the question. Just in terms of reflecting on the previous question, I just want to also underscore that the AG consent can always be delegated down, as it's done in some provinces, to what's called the Director of Public Prosecutions. Okay. In terms of your second question, I would say we're guided by intimidation in terms of intimidation case law as it's been interpreted by courts, because it's a term that's used in the criminal code and also entrenched in the criminal code. But you raise a really important point, Mr. McGregor, which is just this idea of ensuring that lawful dissent and protest, including a labor work stoppage at an important piece of potential infrastructure, is protected and remains protected, and that's why that language has been deliberately inserted into the bill, because we don't want this to turn into sort of a situation where ideology motivates whether people are being coming under the penumbra of potential prosecution initiatives. It is always when there is an element of foreign interference and something that is not proper lawful dissent and protest, but actually transfers into something that is more reprehensible, that is actually trying to influence Canada and subvert Canadian interests.
I think I have room just to get one more question in. So when I'm reading through Bill C-70, there's obviously a thematic nature to most of the amendments. We have important amendments to the CSIS Act, to the SOIA, the Canada Evidence Act, and of course enacting a new act to deal with a foreign registry. What seems to stick out, though, are the amendments to the criminal code, particularly as it relates to sabotage. I'm just wondering if you could provide some rationale to this committee as to why it seems so important to update amendments or update the definition of what sabotage is in the criminal code in a bill that's primarily dealing with foreign interference.
I think it's, in frankness, Mr. McGregor, it's reflected on what we heard in the consultations and where we are as a nation. I mean, it troubles me that the sabotage provision haven't been amended in 75 years, maybe 85 years, since 1951. That is a tremendously long time to not update an important piece of an important sort of definitional provision in our laws. And I think it's also reflective of the fact of what we're seeing. And that's both the work that you guys are doing at this committee, what we're seeing from NCCOP, what we're seeing from Madam Justice Ogue's inquiry. What we're learning about is that foreign interference is very present, and it affects essential infrastructure. It affects various levels of influence in terms of various components of Canadian society. And I think particularly modernizing the sabotage offense is what we need to do to make sure that we are being responsive to the threats that we're facing and ensuring that Canadians have confidence in the approach that we're taking to what is a very pernicious issue. Thank you.
Thank you, Mr. McGregor. And once again, I apologize for kind of redacting you earlier. So we're going to start our second round. We have been terminating our second round sort of after Mr. McGregor. I've requested if the ministers can stay another few minutes beyond that, we will give the Conservatives and the Liberals an additional 2.5-minute slot. So, Mr. Cooper, if you please, 5 minutes.
Thank you, Mr. Chair. Minister LeBlanc, you said moments ago that the House of Commons must be safeguarded from foreign interference. I completely agree with you in that regard, and yet the NCCOP report released this week unequivocally states that elected officials, including certain members of Parliament, are working wittingly, and I emphasize the word wittingly, with hostile foreign states, including frequently communicating with foreign missions, providing foreign diplomatic officials with privileged information, and sending secrets to intelligence officers of foreign states. I would submit that as long as the Prime Minister continues to cover up the names of these compromised MPs, a dark cloud will continue to hang over this place. So I put it to you again, who are the names of these compromised MPs? Who are they? What are the names? What are their names?
Mr. Chair, through you, I'll repeat the answer that I gave to Mr. Cooper's colleague. The release of that sensitive, highly secret intelligence information is governed by law. I think Mr. Cooper knows very well that the
Minister, with respect.
Point of
Mr.
order.
Chair, I was trying to answer the question.
Ms. O'Connell on a point of order.
Mr. Chair, perhaps you need to provide a reminder to committee members that questioners must give equal amount of time for the witnesses to answer. And stop with your
the same point of
pretending
order.
of reading the book.
Ms.
I
O'Connell?
know your favorite
Ms.
thing to do
O'Connell?
on a Friday night is pretend to be chair. But, Mr. Chair, please give a reminder of the decorum around this committee in dealing with witnesses.
Thank you. Well, let's
On the
avoid-
same point of order, Chair.
Mr. Janice on the same point of order.
Yeah, there's no requirement whatsoever for equal time. It's the members' time. That's well established. And whether you read the book on a Friday night or a Saturday night, it will say the
Okay,
same
that's-
thing on that.
We're getting a debate here. Let us continue. Mr. Cooper, I would appreciate if you give the witnesses a chance to answer the questions you ask. Go ahead, sir.
Yes, well, with respect, Minister, I'm not asking you to release the intelligence. I'm not asking you to release sources and methods. I'm simply asking you to release the names. There is no legal impediment preventing you from doing that, preventing the Prime Minister from doing that. So why is the Prime Minister continuing to cover up the names to shield these MPs who are compromised by hostile foreign states?
Mr. Chair, far from it. The Prime Minister and our government have strengthened Canada's ability to detect and counter foreign interference. We're discussing today landmark legislation that the committee is working on that would strengthen the ability of our intelligence agencies and the Royal Canadian Mounted Police to do the important work of holding those that violate Canadian law to account. So, Mr. Chair, again, I have every confidence that...
Minister, we already know that one former Liberal MP, the member for Don Valley North, received help from Beijing to secure the Liberal Party nomination, and we know that the Prime Minister was briefed about that during the 2019 election before that member was elected while he was a Liberal candidate, and the Prime Minister did nothing about it and covered it up for nearly 4 years until he got caught when it was reported in the Globe and Mail. The Prime Minister has a disturbing track record of putting the partisan interests of the Liberal Party ahead of transparency and protecting our democracy and national security. Isn't the real reason the Prime Minister won't release the names because some or all of these compromised MPs happen to be Liberals?
Mr. Chair, through you, I congratulate Mr. Cooper on the clip you probably just tried to get for social media. The simple answer is no.
How many compromised MPs are there? Since you won't release the names, how many are there? Just a number.
Again, Mr. Chair, Mr. Cooper knows full well that the information that underlies the conclusions of our intelligence agencies or the RCMP is highly protected, sensitive information that often comes with caveats from foreign partners.
Minister, I asked you simply for a number. How many compromised MPs are there?
Mr. Chair, Mr. Cooper knows very well, and I get the theatrics. He's very good at that. I think he should be perhaps given a gold star for theatrics. But he also knows...
Minister, this is about as serious as it gets, that we have members of Parliament working for hostile foreign states. You won't release the names. At the very least, Canadians deserve to know how many MPs are compromised. How many?
So again, Mr. Chair, I explained earlier this week, and perhaps if Mr. Cooper is interested, the director of CSIS or others could explain the challenge of taking.
Minister, perhaps we can
He's
narrow it
obviously
down.
not
Are any in
interested.
cabinet? Are
He's
any
obviously-
sitting around the cabinet table?
Mr. Chair, Mr. Cooper can pretend to be a prosecutor if he wants. I was.
Pretending to be anything. I'm asking you a very straightforward question as to how many compromised MPs there are, and are any in cabinet? Just an answer.
Thank you, Mr. Cooper. That's your time. The minister may answer if he wishes.
No, Mr. Cooper doesn't seem to be interested in the answer. He's more interested in interrupting, so we'll go to the next question.
Well, I didn't answer.
Thank you. We go now to Ms. O'Connell for 5 minutes, please.
Thank you, Chair. Thank you to the witnesses for being here. Minister LeBlanc, has the leader of the official opposition, Mr. Poilievre, received his security briefing, or security clearance, sorry?
Mr. Chair, through you to Ms. O'Connell, no, he has not, because we've offered, as I think colleagues know, on a number of occasions to process the appropriate clearance for the leader of the opposition, so he could perhaps see some of this exact information that his colleagues seem so interested in us releasing, but he has not made such a request.
And is the offer to provide him that opportunity for security clearance still available to him?
Of course it is, Ms. O'Connell, and we were very pleased, for example, the leader of the New Democratic Party accepted our offer, and we think that's a collaborative, constructive way to make Parliament, to increase the confidence that Canadians would have in our democratic institutions.
So, Minister LeBlanc, Mr. Cooper just said this is an issue as serious as it gets, yet his leader refuses to receive a security clearance that would actually allow him to have the full information that, frankly, NSICOP members would have. It would allow him to be able to go to Canadians and his own caucus to say, listen, I've reviewed the information. I can't reveal the details. However, I feel confident that some information is uncorroborated. I feel confident that other information is further being pursued by law enforcement, but I feel confident in our democratic institutions. Instead, in, quote, the most serious issue as it gets, according to the Conservatives, they purposefully decide to be ignorant to the issue, instead throwing around fake sanctimonious accusations about numbers of compromised MPs, what that might mean. And, Minister, what this provides in the sanctimony of pure chosen ignorance by the Conservative Party is the fact that it will create mistrust and distrust in our democratic institutions with the ability to be informed. Their very own leader has the ability to be fully informed of what's going on in this serious matter. Instead, choose blind ignorance, which creates mistrust, distrust, and who benefits most from mistrust in our democratic institutions? Foreign states who hope to influence it. And Mr. Minister, it's also, accusations have also been thrown out about influence in the leader of the opposition's own leadership race. However, is it not completely inappropriate to start making accusations about some pieces of intelligence and funny enough, it's actually my time and I can make comments, but funny enough, they leave that accusation out of their comments. Do you find it irresponsible for a leader of the official opposition who hopes to be prime minister one day to be so ignorant and blind to, quote, such a serious issue, as serious as it gets?
So, Mr. Chair, through you to Ms. O'Connell, thank you for the question. And you're absolutely right. If the leader of the opposition was serious in understanding the information underlying the NSICOP report, and Ms. O'Connell has served on this committee of parliamentarians herself, so would know this better than I do, but the committee produced two reports. It produced a top-secret report for the Prime Minister and for our intelligence agencies, and it produced a report that was released publicly earlier this week. And the report that was released publicly, of course, was subject to all of the appropriate legislative protections, and Mr. McGuinty has spoken about this publicly. But if the leader of the opposition was interested in seeing the highly sensitive information that the Committee of Parliamentarians saw, that informed their top secret version of the report, he would simply have to indicate that he is prepared to receive the appropriate security clearances, and then he would have access to that information. So I think in the way, for example, the leader of the New Democratic Party can and will. So to us, that is a responsible, thoughtful way in the difficult world of intelligence information that comes with caveats and the need to protect sources and methods. That, to me, is a responsible, thoughtful way to do it. It's not the path the Conservatives have chosen. And I thought your speculation as to some of the reasons, Ms. O'Connell, were absolutely valid.
Thank you, Chair. Minister, the Conservatives would like to pretend that this is somehow a cover-up. However, the information that is protected and deemed secret or top secret status would be governed by law and legislation. Was that law and legislation in place during previous governments, or is this somehow new law? Things like the Espionage Act?
So, Mr. Chair, again, a very good question. The protections of this information, and the director of CSIS and the RCMP have spoken about the reasons why it's important for us to be able to do this work and the law that governs that. It's no different from conversations I've had with Five Eyes colleagues and other allies of Canada. But in terms of the particular legislation that's existed for a number, perhaps the director can give you a quick sense, Ms. O'Connell, of the different pieces of legislation that govern the release of this information and how long they've existed. I know we're celebrating CSIS's 40th birthday this year. All of you, I'm sure the director will invite all of you to the party in a second. But perhaps David wants to add something.
Yes, thank you, Mr. Chair. The legislation is quite clear and has been in place for some time. The Security of Information Act is there to protect sources and methods, but also protect against disclosure of information that would be injurious also to the people. And I think we have seen, the impact of the leaks, and when classified information is released, there are challenges that, comes with it that, we try to make sure that in a democratic environment that we address the national security threats, but that we are also addressing, and we're doing it in a manner that is respectful of the law.
Thank you. And this actually is the protection of people, is not protection of some opposition leader or some parliamentarian. It's actually those who are serving our country, collecting this information, who could be put in danger by the release of sensitive information.
Ms.
Is that not accurate?
Sorry, I was distracted by other things. You're way over. We'll have to cut it there. On y va maintenant, Monsieur Villemure.
We now turn to Mr. Villemure. You have 2.5 minutes. Thank you so much, Chair. I'll do what I can in 2.5 minutes. Mr. Virani, Honourable Minister, you have carried out a number of consultations before this bill came down. How much time? For how long were we consulting? The most recent consultations lasted for a few months, and before that, before I arrived in Cabinet, I will ask the officials accompanying me to help me with that, to provide an answer.
The consultations on the justice parts of the bill ran from November to February, I believe. And prior to that, there were consultations done by our colleagues in public safety on the registry that I believe started in May of 2023, if memory serves.
So about 3 months.
2 months, yeah.
2 mois pour les...
And then another 2 months. All right. So 2 months for the public safety elements and 3 months for the other parts. That's why I find it difficult to look into this in 4 days only, because the implications are deep, serious, and this is working a little too fast. I'll get back to what you said earlier. It's true that party leaders can request security clearance at a level that would allow them to examine secret information. But that being the case, they're also held to keep this information secret. So the offer is much appreciated, but isn't very useful to us. Would there be any other way we could use to get the information besides that? Once again, I understand how sincere your question is and understand your concern. So possibly, Mr. Villemure, let's say that the leader of a party had access to a secret report from NCCOP, the version that cannot be made public, and used that information to make some responsible decisions in their capacity as leader of a party. That is one scenario, and you're quite right. The leader of a political party, just like all of us, like my colleagues in the intelligence agencies, is held to secrecy. So you're right on that. But it might be a good tool that they would have to help them make decisions, let's say, about nominations to his party, potential MPs. Yes, but nevertheless, the secret part would have to be respected. Yes, thank you.
Mr. McGregor, please, 2.5 minutes.
Thank you, Chair. Very quickly, Minister Varani, we've heard the term transnational repression come up from a few witness groups. Are you satisfied that the amendments to SOIA in this bill cover what groups are concerned with on transnational repression?
I am. I think we've listened to that concern, and I think we've addressed it in as flexible a way as possible to capture as much transnational repression as we can.
It's been something I've been just wondering as a committee member. Minister LeBlanc, I want to turn to you. I think from the exchanges that we've had, there's an obvious difference between intelligence and evidence, and there's a real struggle that, you know, it can be a struggle using intelligence to get to evidence because of the secret nature of the sources. I understand all that. And I also understand that, that our leader, Mr. Singh, he took that briefing because, of course, foreign interference has directly impacted him personally. And we know it has affected his personal life, where he can go, his family, and so on. I think that's very much public knowledge. But I wanted to know, I wanted to get your thoughts just on Part 4 of this bill. When we're creating this public registry, there's a definition in the bill on arrangement, and it reads out, you know, being under the direction of or in association with. Now, this is going to be a public registry, but there's a very real difference between being under the direction of a foreign principal and in association with a foreign principal. So I'm just would like to hear from you, how do you see the difference between those two terms? And, you know, this is going to be a public registry. It could have some severe implications for the people who are put on it, even if they're just in an association with a foreign principal.
Mr. Chair, through you, Mr. McGregor, thank you for the question, and I think you're right to identify your leader's thoughtful approach to this issue, and I think Canadians, because it was part of the public record, were understandably upset in terms of him and his family potentially having been targeted in some of these contexts. So I certainly continue to share a concern around his ability to do his work as a parliamentarian. And you raised, Mr. McGregor, a good question. I know that Mr. Bilodeau, who's worked on the details of the registry in terms of the principles and why we all, I hope, are in favor of the registry are well known. I won't repeat them, but the specific distinction as to in association with or under the direction of, I do get thinking about a solicitor-client relationship, for example, how that might be different, but maybe Mr. Bilodeau can give you a precise answer to that question because it's a good one.
Thank you, Minister. And Chair, the answer is that the bill is intended to capture a broad variety of arrangements that doesn't require to be in writing, but there would still need to show, the Commissioner would still need to show that there is some sort of understanding between a foreign state and an entity in Canada to conduct the influence activities. And it was built this way to allow the Commissioner the flexibility to enforce the legislation. To the point about individuals being identified on the registry, by virtue of that arrangement, there are recourses within the legislation that an individual who felt that he or they should not be listed, there's an opportunity for judicial review of that decision, and so the safeguards are built into the legislation. And the last point I would make is that the Commissioner will have the ability to issue interpretation and guidance, and that could inform how they will see what they consider an arrangement.
Mr. Chair, if I could just add in 10 seconds, the registry is not sort of a stigmatizing entity where it's sort of implying criminal conduct or inappropriate conduct. It's a transparency document, so it's an important distinction.
Thank you, Mr. McGregor. So we're substantially over time, But since I messed up with Ms. O'Connell and gave her substantially more time, I'm going to give Mr. Motz 1 more minute for a question.
Thank you very much, Chair. Thank you, ministers. So, given the importance of C-70, we know that Parliament has been doing its job, and now we want the government to do theirs. So, will each of you ministers commit today to have C-70 in place and fully implemented before the next election? Yes or no?
That's certainly our objective, Mr. Chair. We recognize the urgency. That's why we appreciate, as I said in my opening comments, our House's work. We don't know what the Senate will do. But the elements that are within the government control, I can assure our colleagues in terms of the implementation of the legislation, we will ensure that they're in place.
Just quickly, how do you plan then to implement that? An order in council or some other thing? Because the officials have said it could take a year. We may not have a year. So would an order in council suffice to make sure it gets done before the next election?
Again, I'm not an expert in terms of an order in council. Certain provisions of the appointment of the commissioner, all of these things will be proceeding expeditiously, consulting Parliament, of course. But maybe Mr. Varani, in terms of the order in council coming in. But Mr. Mott, it's a very good question. I think colleagues should be under no illusion that we very much, like I think you do, want to have this in place before the next potential election. That's why we're so encouraged by the work that's going on here. But Arif, did you want to add something?
Yeah, I would just say that Minister LeBlanc and I will work cooperatively to prioritize this legislation. It's very, very important, as has been underscored. I would just note, Mr. Motz, that the coming into force provisions are 60 days after royal assent. We can't control the Senate process, but we'll do everything in our power to ensure legislation of this nature is prioritized.
Thank you.
Thank you, Mr. Motz. And thank you, ministers, for all of your great testimony today. It's most helpful. So we are going to be losing a few of our officials, and we will be getting a few new ones. So we will suspend as we replace the panel.